Good afternoon, everyone. This is John Greenhall. I'm here with my partner, Lisa Wampler. We're both members of the Cohen Seglias Contract Review and Risk Management Group here at, again, Cohen Seglias. Today, we're going to be presenting payment terms, a trap for the unwary. This is our second of four CCRM webinars for this year. Please, if you have any questions during the course of the webinar, there is a question and answer drop down that you can simply type your question in, and we will try to answer as we go along rather than waiting until the end. In addition, we will be sending you a copy of the slide deck, and if you have any questions after you receive that, please feel free to contact Lisa or myself. With that said, let's get into this. As I said, my name is John Greenhall. I'm here with Lisa Wampler, and we are your presenters today. The topics that we're going to cover over the next hour involve basically 5 traps that arise out of your contracts and your payment terms in those contracts. It's important to know what's in your contract, the recognition of those issues, including retention, the dreaded concepts of pay when paid and pay if paid, monthly releases in order to get payment, and withholding performance, what your rights are to do that, and how that is impacted by your Prompt Payment Act in the jurisdiction in which you are working. So let's look at trap number 1, what's in your contract? As they used to say, for those as old as I am, it's like Prego spaghetti sauce. It's in there. And you need to look in your contract for both an integration clause, which is in almost every contract, and an incorporation clause, which is in most contracts. So let's talk about what those 2 clauses are and how you can spot them as you review your contract form. So an integration clause reads like this, and this is true not just for subcontractors, but for general contractors as well. So as you look at this clause, wherever it says subcontractor, think contractor, and wherever it says contractor, think owner. But an integration clause is going to say this subcontract constitutes the entire agreement between the parties and supersedes all proposals. So whenever you see the words entire agreement and with it superseding the proposals, you need to watch out. And the reason why you need to watch out is if there is an integration clause, anything that is contained in your proposal is no longer valid. It has been superseded by the agreement between the parties. So let's look at a couple examples. Here's one from a Turner subcontract. This says that this agreement constitutes the entire agreement and no oral representations or other agreements have been made by Turner except as stated in this agreement. Another purchase order that I've seen has an objection to any additions, exceptions, or changes unless it's contained in the contract and approved by the contractor in writing. So how do you deal with the fact that what is in your contract or your proposal is not in your contract? You have to make sure that your proposal is an exhibit to your contract and that it is a controlling exhibit in the event of a conflict. There
Just
are
to jump in, I was just going to jump in there, John, for a second. You know, oftentimes actually your contract's going to have a scope document. So you probably are going to get some pushback in attaching your proposal. But with a scope document that's attached as an exhibit, that's also a great place to put the terms of your proposal if you have exclusions or clarifications when defining your scope.
Right. So for your scope of work, the exclusions and clarifications are key. But with regard to payment, there is an impact due to the integration clause. For example, one of our clients has a quote to general contractors that says payment of invoices, all invoices are due 30 days from the invoice date. Well, the purchase orders and the contracts say things that obviously differ from 30 days from the invoice date. We've seen it 70 days, 60 days with 0% interest, which means that they could just keep not paying you. We've seen it 30 days from when the owner pays us, and we'll get into pay when paid and pay if paid later, or 10 days after receipt of payment from the owner, but the owner has 70 days to pay. So in other words, you submit your invoice, you're expecting payment within 30 days, but in reality, you're going to get 80 days later payment. So which controls? If there's an integration clause in your contract, the terms of the subcontract itself and not the terms of your proposal is going to control, and you're going to be guided by all of these other payment terms, not what was in your proposal. That is made even harder by the next clause that we were talking about, which is incorporation by reference. Here in your subcontract, the owner's contract with the prime contractor becomes controlling. So you'll see an incorporation, many times it'll say right in it, incorporation. Other times it'll just say you owe to me what I owe to the owner and vice versa. But these clauses do control, and anything that is in the prime agreement will now be considered to be in your subcontract. So you'll, for any of the subs out there who have been working at all, you will know that anytime a GC gives you a contract, it's going to say, you owe me the prime contract. And then many times they don't give you a copy. You must see that prime contract or any other reference documents before you execute your subcontract. You have to insist on seeing it. Even if they say you have to come down to the job site and look at it in the trailer, you have a camera on your phone, you go, you take a picture of every page of that contract so that you can look at it later. We have seen horrible clauses in owner contracts that subs are being forced to follow. Payment terms like 180-day payment, retention provisions of 20%, notice of issues within 24 hours. These are things that will be found in the prime contract, even if the subcontract is silent, and you must obtain a copy of that prime contract. So now let's go on to trap number 2, which is recognition of issues with proposed payment terms. Most contracts, and this is true from both the GC in a prime contract and a subcontract situation, there is a requirement that you prepare a schedule of values. And I'm talking about stipulated sum contracts, and that you then bill against that schedule of values based on a percentage of completion. The issue is that many owners and some general contractors consider that schedule of values as if it is a line item guaranteed maximum price for each particular line in the schedule of values. So if it says that there's a $1 million electric line item in the schedule of values, that if it goes over that amount, that's on you, it's not on them. The issue though comes up not when by going over, the issue comes up when they want to take away work from you, because they see that $1 million line item on electric and they say, you know what, we're going to take away 250,000 of a quarter of the work that's worth 250,000. The reality is it's not, that the schedule of values is just a guide for how you're going to get paid. It is not a dollar for dollar comparison of the electrical work versus all of the other work that needs to be done on a project. I have seen unsophisticated owners trying to get credits based on the value shown in the schedule of values. It needs to be explained to them that the schedule of values includes your general condition costs and other costs that may not be perfectly allocated throughout the schedule of values. There are also payment terms such as I have to bill until the end of the month, but I have to submit my bill 5 days before the end of the month. It is a contractual requirement, though most people don't recognize that in AIA contracts, that there's a built-in pencil copy version of your application. You provide them with a document based on your schedule of values, a payment application, and then they're supposed to tell you whether that is acceptable or not. It's going to cover through the end of the month, and you project what you're going to spend through that time period. You would then submit the application, and the architect has to tell you whether or not they agree with that. We'll talk about deficiency notices later on for how quickly the architect has to respond, and we'll get into that later on in the presentation. The other issue that comes up a lot with regard to payment is retention. As most people know, retention is there to keep the contractor's feet to the fire and make sure that they come back and they complete the work and complete the punch list after substantial completion. The standard that we see is a 10% retention throughout. It is our suggestion that any retention should be reduced at 50% completion. By doing that, you can give, especially the early completing subcontractors, additional money so that they can remain happy with their payment terms and also avoid the potential for them leaning the project. Most owners will agree to that, but will want a 5% retainage thereafter, so that at the end of the job, they're holding 7.5%. Sometimes they will agree to hold 0 thereafter, so that at the end of the job, they're holding a 50% retention. Your contract should also address what happens at substantial completion. Usually this is based on a valuation of the punch list by the architect. I was looking at a contract this morning, though, which said that the owner was going to do that valuation. You should try to avoid that for obvious reason, because the owner will put a higher value in hopes that they can hold more money to force you to perform things that you don't think need to be done. But generally at substantial completion, there's a reduction to either 150% of the value or 200% of the value. So retention is negotiated. Do not just assume that since the owner put in 10% all the way through, that's what it's going to end up. That is one of those areas that owners do bend on. And I would suggest as a contractor or subcontractor to try and follow the sample that's on your screen now. The AIA contracts have a specific section for the reduction of retention, and you should make use of it. So retention in subcontracts, though, are all over the place. You would think that a contractor needs to have the same amount of retention that the owner is holding against them in their subcontract. That is not true. A contractor, depending on the language of the prime contract, may hold more money against the subcontractor than is being held against them. I do not suggest that contractors do that, because it could violate the prime contract, which requires you to pass on whatever monies you receive from the owner to the sub. It could violate a statute such as a trust fund. So I instead prefer to have the retention amount mirror that is being held in the prime contract. So again, some examples from the real world. Here's one that just says we're going to hold 10% until the completion of the project. It doesn't define completion. Does that mean final completion, substantial completion? No one knows. I've also seen ones similar to the bottom provision, where it says the rate of retention is going to be equal to the percentage retained from the contractor's payment by the owner. That is a good idea. It's a good clause for those general contractors out there. And for the subcontractors, they should demand, again, a copy of the owner contract to determine what that retention amount should be. Lisa?
All right, so let's move on to trap number 3, which is the difference between a pay when versus a pay if paid clause. This is probably the most often misunderstood type of situation, as well as one of the most hotly contested clauses in a subcontract. So we kind of wanted to just highlight to you the differences so you can pinpoint which one you have when you're reviewing your agreements. Subcontract agreements obviously are most likely going to have a clause that makes the contractor's obligation to pay the sub contingent upon the general contractor being paid by the owner. And that is exactly what a pay if paid provision is. In New Jersey and Pennsylvania, including other states, they enforce pay if paid provisions as long as there is a clear language in the agreement that unambiguously reflects an intention by the parties to shift the risk of non-payment by the owner to the sub. There's usually language that at least says that payment from the owner is an express condition precedent, but most of the time the language included also goes beyond that to show that the risk is being shifted. If it doesn't have this kind of language, this express condition precedent or risk shifting language, then the provisions are typically interpreted as addressing the timing of payment. And I will note that not all states actually enforce pay if paid clauses. If you're working in New York or Delaware, there's actually statutory authority that makes pay if paid clauses unenforceable. So let's look at what a pay if paid clause looks like. So this is what a typical pay if paid clause is going to read. Okay, let's look, we're advancing too quickly here. Trying to move back. Okay, so the language typically says payment from the owner to the contractor is a condition precedent to payment from the contractor to the sub pursuant to this article. So again, it has this language, condition precedent. That's what makes it a pay if paid clause. And what that really means is that your payment is 100% contingent if you're a sub on the GC receiving payment from the owner. And if the GC doesn't get paid, then they have no obligation to pay you as a sub. We talked about how there's that magic language that it's a condition precedent. Obviously, this is a provision that as a subcontractor, you want to avoid at all costs because you're not really entering into a contract to perform work for free. On the other hand, you're dealing with a general contractor who also doesn't want to be on the hook to pay you if it hasn't received payment from the owner. In this situation with a pay if paid clause, again, the sub is taking the risk of the owner's non-payment for whatever reason. It could be that the owner's not paying for reasons that have nothing to do with the subcontractor's work, as well as just that the owner, is having financial problems and can't make payment to anyone. Often contracts also will condition, make the condition of a pay if paid clause also applicable to sureties, so that if there's a payment bond in place, that the surety has the right to rely on that pay if paid clause as a defense to payment as well. So having a payment bond that's similarly conditioned with a pay if paid clause essentially makes that payment bond virtually worthless because the surety is not going to be making payment regardless. Now we're going to contrast what I just discussed with what a pay when paid clause looks like. And you'll notice here that it just says that the contractor is to make payment to the subcontractor within 7 days of contractor's receipt of payment. There is no magic language that suggests that it's contingent upon receipt of payment from the owner. It's not an express condition precedent. There's no language that shifts the risk of non-payment. And these types of clauses are more acceptable to courts than the pay if paid clause, because what it designates is that the contractor has a reasonable period of time. So even though this says contractor shall make payment to sub within 7 days of receipt of payment, which, by the way, makes it very important for you to go back to what John says, is another reason to look at the prime contract, because you want to also know how quickly the owner is required to pay the contractor, so that you can figure out the earliest that you can be expecting to receive payment on the project. And at all costs, you should try and limit the period of time when the money is deferred. This says 7 days. I've certainly seen 60 or not 45, 60 to 90, which can really push the timing of your payment far out beyond what is reasonable. So let's look at a few examples of a pay if paid versus pay when paid. And I wish we were taking, having a little quiz here to see how many people would get this right. But the subcontract language we have here says progress payments to the subcontractor shall be made no later than 7 calendar days after receipt of payment from the owner. Again, no magic language. This makes this a pay when paid clause. Below that, the purchase order language here says that payments shall be due to the vendor within 10 calendar days of receipt of payment from owner. Again, there's no magic language in there, so this is another instance of pay when paid. Even though it says that they're not to pay you until receipt of payment from the owner, you're not seeing any trigger words like express condition or risk shifting language that would make this a pay if paid. Now here's a further example in a purchase order. It starts out saying that payment shall be due until 7 days after contractor receives payment from the owner. And so that standing alone would make this a pay when paid clause. But then the paragraph after that has some additional language that indicates that contractor's receipt of payment is an express condition precedent to the contractor's obligation to pay the sub, except in jurisdictions where prohibited by law. So again, this has that magic language, the express condition precedent language, that would make this a pay if paid clause. From a subcontractor's perspective, and trying to negotiate clauses, most of the time, you're going to get pushback from a GC. They're not going to agree to remove the express condition precedent language. There are certainly ways that you can negotiate these clauses to make them, a little bit more fair. I and John often recommend language that says, if the reason the owner is not paying, it has nothing to do with the subcontractor's work, if it's due to defective workmanship by the GC or others, or delays that were not caused by the subcontractor, that the contractor will at least agree to pay within a certain period of time. I think usually we use something like 45 days or something like that. But there are ways to try to negotiate this pay if paid clause to make it a little bit more fair as a subcontractor. The next trap we want to discuss are monthly releases. What you're going to find in this day and age, that releases are not just in lien waivers anymore. You can find them in payment applications. You can find them in change order forms. So what we're talking about right now is how do you ensure that you preserve your payment rights if you have claims, whether it be claims for delay, claims for disputed or pending extras. You always need to make sure that you're reviewing all of the documents that you are signing in exchange for receipt of simply progress payments, to make sure you're not giving away your rights to payment for other things. With respect to payment on an application, that alone is not going to be sufficient to waive claims not covered by the payment. But you do need to be aware and cautious of waiving any claims that you have through the execution of your monthly payment application. There can be language on monthly payment applications that say, in exchange for this payment, you are acknowledging that you've been paid to date for all work performed through the date of the payment application. And so if you have pending change orders that for work that you've done, disputed change orders, you want to make sure that you are not giving up your rights to get payment for those when you sign the pay apps. In addition to the payment applications, obviously, in most instances, projects require that contractors and subs sign partial release of liens. It's equally as important when you're reviewing the payment application form that you're also reading the release of liens and/or waivers, because gone are the days that lien waivers are just that, and that they only are waiving lien rights. They also now contain language that constitute waiver of all claims up to the date of the payment application. And if you have any pending change order requests, extra work, claims that you've submitted for additional payment or time, you absolutely cannot sign a release of liens and/or waivers that have broad waiver language without reserving your rights. There is no such thing as duress under the law. So, you can't say, well, I needed to sign this because I need to get paid for the work that I performed. That's not going to save the day if you've signed something that gives up your rights. As a sample of the monthly release and what you should be looking for, this first sentence here obviously looks like a normal lien waiver. It says you're releasing lien rights, mechanics liens, and equitable liens for the labor and material that you provided. But then there's this secondary language at the bottom of this form that has that makes this waiver much broader. And it has language that says it's either a partial or final release of all claims, damages, demands that you have against the contractor and owner. And they go as far as to include claims that you ever had, now have, or ever will have against the foregoing. And it includes all claims for damages. Oh, I guess that's not highlighted. All claims for damages associated with delay, disruption, acceleration. So again, you can see how broad of a release this is, that essentially it looks backwards, current and forward. And you need to make sure that you're adequately, you're reviewing these with a fine-tooth comb, and that if you have any claims or pending disputed change orders, that you're reserving your rights, because by signing this, you will be giving them up. Okay. This is, again, what we just looked at, just in a different format. But you will note that this typical release language that's included here at least accepts out claims for any retainage that has not been paid through the date of signing. So in the concept of accepting out, it's our recommendation on a form that has broad waiver language that you include a statement on the actual form itself that indicates that you're not waiving and that you are specifically reserving all your claims for additional compensation and/or time for the work performed on the project. You should definitely be as specific as possible so that the individuals who are reviewing these waivers and release forms understand what specifically you are reserving. If it comes to open change orders for work that's been performed, I would even recommend that you attach a pending change order log so that everyone's working off the same information, and there will not be a question as to what exactly it is that you claim that you're still owed money for. So if we recommend that you write it exactly on the form when you submit it, but oftentimes we see owners or GCs rejecting that language. They want to clean, especially GCs. They don't want to be turning in, lien waiver forms that are all marked up to the owner. So oftentimes modified lien waivers will get rejected. So what do you do when that situation arises? Well, we recommend that if you absolutely need to get paid, you have to sign the waiver without an additional statement. We recommend that you do a side letter contemporaneously with signing that lien release that says, you know, I've attempted to make modifications to your lien form because I have advised you that I have these claims and outstanding change orders. You've told us that you won't accept a modified lien waiver form, but we're putting you on notice that by signing this waiver unaltered, that we still have claims and we're still reserving our rights to those claims. And again, be as specific as possible in that letter as to which claims you have that you're reserving your rights to. Now, I don't necessarily know that there's a lot of law out there as to whether or not that procedure will protect you when it comes to getting paid. You know, having this side letter, I mean, the whole point of this is for the other side to know that I still have claims out there. And so it eliminates the argument that there's any prejudice by the other side to knowing that you haven't given up what you have, and you're also putting them on notice of what claims you still have. So you should definitely, when you come across this situation and you're reviewing your lien form that you have to sign, and you know that you're in a situation where you have submitted claims, you should definitely be consulting with your attorney to make sure that you're adequately protecting yourself. This, you know, when you have claims, not only, you know, do you need to worry about preserving them, but, you know, keys to recovery of any claims for payment. You know, you want to make sure that you can quantify your claims, that you're providing the right notice in your claim from your subcontract. You need to refuse to execute those releases and or modify them to preserve your rights. And that we haven't talked about change orders, and I don't have any examples to show you, but as I said before, waiver of rights can be found in change orders, lien waivers, payment applications. So you need to be looking at all three kinds of documents. And we also suggest, again, when you're trying to make sure that you are preserving your rights to payment for any claims, that you have monthly evaluations with your project executive and project managers, as well as actually your accounting group. You should be looking at where you are in the project and discussing why you're here. If the job is behind schedule, everyone should be asking, why is it behind schedule? Is it because of something that the company has done, or is it for reasons unrelated to the company? And those raise further questions about what the company should be doing about it. Obviously, if it's company-driven delay, you need to be discussing how can we correct that delay. If it's related to someone other than the company, you have to make sure that you're giving the right notice, you have the right documentation, you're writing the right letters, and all of these things, again, you know, will help you along the way in terms of getting paid for your claims. All right, John.
Well, thanks, Lisa. Trap number 5 is withholding performance. The issue here is, when can I stop doing work? We get calls from clients almost every day saying, I'm not getting paid. Can I leave the job and let the owner fly in the wind? And the answer to that question is not necessarily. You shouldn't abandon a project. That's your last resort. You have to look at what the contract provides. There are notice provisions in the event of the owner's default. There might be suspension rights and a right to seek assurance that the owner or general contractor has sufficient money to pay you. Each of those clauses can be found in either the prime contract or in your subcontract form itself. So most agreements provide that the owner or GC can withhold payment to the subcontractor or GC, depending, because of various reasons. And here's an example, which, as it shows here, goes on and on and on about different reasons why payment can be withheld. But interestingly, this provision provides that before they withhold, the contractor has to give written notice to the sub as to why the contractor is going to withhold payment. Then the sub has 5 days to take appropriate corrective action. What the contractor is sending them here is what is commonly referred to as a deficiency notice. It may not be called that in your contract. Some statutes actually call it deficiency notices, which we'll talk about later. But if they fail to do this, they waive their ability to withhold money and are in breach of contract until they satisfy this requirement. So what can you do if they withhold payment? Again, they have to put you on notice. The deficiency notices have to be sent within a certain amount of time. Even if your contract is silent, your payment acts will have a specific number of days to send that deficiency notice. For example, in Pennsylvania, it's 14 days. You need to make sure that the contract is clear as to when you're going to get paid once the reason for withholding is removed. Sometimes it's you get to apply for it again in the next month. Sometimes it's you get to apply for it as soon as the deficiency has been resolved. You should also make clear that just because there's a deficiency that they can't hold the entire payment application. I've seen that used by some owners and have modified that successfully. And also make sure that one of the reasons for withholding isn't something that is covered by insurance. Recently, there's been an uptick in the number of clauses that allow an owner or GC to withhold money if there's a claim by a third party for personal injury until the insurance company says we are going to cover it. And for anybody who has dealt with insurance, you know that rarely happens. There's always a reservation of rights, and they should be, the clauses should be revised to reflect a should be covered as opposed to definitely will be covered. So it's important to look at the prime contract again here. Most prime contracts have a right to suspend work for non-payment. The AIA contract, for example, gives you a 7-day notice where the contractor sends that notice to the owner that they're going to stop work until the payment has been received. Not enough people make use of this. It's not withdrawing from the project. It is merely suspension. So with that, I'm going to turn it over to Lisa to talk about specific Payment Act rights. We're going to try to cover as many states as we can in the few time that we have left. But she's going to address Pennsylvania.
Yeah, so the contract is not going to be the only place that controls your payment rights. There are prompt payment acts in each jurisdiction. I don't know if every jurisdiction has them, but they are statutory in nature. So they're enacted by the legislation of each state. And so the terms of those prompt payment acts are going to differ from state to state. So they're not uniform, and you need to know what the payment act in the jurisdiction of your project says. Some will apply to both public and private projects. Some only have them for private, some only have them for public. But the general idea in all of these statutes is that they govern payment downstream and have timelines for when payment must be made unless there is an express reason given for not making the payment. And again, that's the concept of the deficiency notice that John mentioned earlier. So what exactly is a prompt payment claim? Again, under the various state statutes, they allow for a claim to be made where there is a failure to timely pay for materials and labor provided by others, and it imposes unfavorable consequences on those who are breaching the timeframes for payment. If you are doing work in Pennsylvania, we have two statutes that exist for prompt payment. The first being the Public Prompt Payment Act. It's also known as the Procurement Code. And then for private projects, we have the Contractor and Subcontractor Payment Act, which is also known as CASPA. So let's talk about CASPA first. Again, it applies to construction contracts for work performed on property that's located in Pennsylvania. And this is a statute that governs private projects. And it requires that the paying party, whether it be the owner or the contractor, that they pay downstream strictly in accordance with the terms of the contract. And I think John mentioned that these statutes also can serve as placeholders for subcontracts that may not have language specifically with respect to timing. The CASPA does have a time frame when an owner must pay a contractor and a contractor must pay a subcontractor, but the terms of the contract, to the extent they have timing mechanisms, will control. And if these payment terms in your contract are not followed, what CASPA gives you as the unpaid party is entitlement to interest at 1% per month. So that's 12% annual. And you get the possibility of recovery of penalties at an additional 1% per month, and also your reasonable counsel fees. So in terms of what constitutes an untimely payment under CASPA, as I said, CASPA has its own rules with respect to payment, with respect to contractors paying subs. It requires that payment be made within 14 days after receipt of each progress or final payment, or 14 days after receipt of the subcontractor's invoice, which is later. So I mentioned earlier about needing to consult the prime contract when it comes to due dates for payment. I just wanted to again raise that as an issue, that as a subcontractor, before the subcontract is executed, you should make sure that the contractor is disclosing the due date for receipt of payments from the owner. You'll see that in different formats. Some just say, see prime contract. Others will, specify the timing for payment. But it's very important that the due date for payment from the owner be disclosed, because if it's not as a contractor, What CASPA does is it requires you to pay as if the owner has made payment to the contractor 20 days after the end of a billing period, or 20 days after delivery of the contractor's invoice, whichever is later. So if you don't disclose the due date, you could be required to make payment even though the owner has not paid accordingly. Just some examples of what CASPA can do to a damage award when you are not timely paid. These are 3 examples of where, the awarded column is what was awarded for amounts unpaid, and then you can see when CASPA damages are applied. For instance, in the 3rd example, there was $30,000 awarded for contract balance. And then with CASPA damages, they ended up being awarded $1 million. So it can be a nice financial hook if you can recover under CASPA. John mentioned suspension of work rights that are included oftentimes in contracts, including the AIA. If you do not have a contract as a subcontractor that has suspension rights in them, rest assured, CASPA has now included language that gives an unpaid subcontractor the right to suspend work without penalty if they're not getting paid on time. The deadlines and the period of time that you have to wait in order to suspend work tends to be a little bit longer under CASPA than a traditional subcontract provision. Under CASPA, you have to wait for 30 days to pass, and then you have to give an initial written notice within 30 days after the end of that billing cycle. Another 30 days you have to give notice to the owner, and then even after you've given those 2 written notices, you still have to wait another 10 days before you can suspend work. So in reality, you can't suspend work until 70 days passes following the end of the billing period. Contractors equally have the right to suspend work when an owner's not paying on a timely basis, and the same kind of time frame applies with respect to needing to give notice to the owner. The concept of this deficiency notice is also covered under CASPA. A contractor is entitled to withhold payment for a deficiency item, but CASPA has some requirements that must be followed in order for the contractor to make that withholding. The contractor is required to notify the sub and the owner in writing regarding the claimed deficiency. And that's either within the time period that's specified in the contract or within 14 days after receipt of the notice of the deficiency. A failure to comply with this notice requirement is a waiver of the basis to withhold payment. And then there is a requirement that when the deficiency item has been completed, that payment must be remitted. There are there is a clause in CASPA that also allows an owner to withhold payment, and it's similarly bound to having to give that written notice to a contractor within 14 days of receiving the invoice. But there isn't the same kind of language regarding the terms of the construction contract. The language indicates simply that the owner will waive its right to withhold after those 14 days, and there are no exceptions to that. In terms of retainage, there are also now new limits in CASPA on how long retainage may be withheld. Under CASPA, retainage cannot be withheld for more than 30 days after final acceptance of the work, unless, again, there's been that written notice of deficiency and it's been properly and timely provided. Any violation of payment with respect to release of retention also entitles you to CASPA damages. And lastly, and, before this non-waiver provision was included in CASPA, we saw a lot of general contracts that would attempt to waive the protections of CASPA, meaning, there would be a clause that says the subcontractor agrees that it's not entitled to any of the protections under the Contractor and Subcontractor Payment Act. CASPA now prohibits any language in a contract that waives the protections of the statute. So even if it is in the subcontract, that language is going to be unenforceable. So the bottom line in all of this is that the parties cannot contract around CASPA protections. And just a quick overview, because the Prompt Pay Act for public jobs is very similar. The Public Prompt Pay Act, or the Procurement Code, that applies to construction contracts that are more than $50,000 on public projects. Again, it's very similar to CASPA, but the specifics are going to differ. I would say the biggest difference, however, is that in order to recover penalties and attorney's fees as part of the damages under the procurement code, that you do need to establish that the withholding of payment was done in bad faith. Like with CASPA, the code requires that any payments are made in strict accordance with the terms of the contract. And if there aren't terms in the contract with respect to payment, they have those default provisions. All right, and John's going to cover the prompt pay laws in all other states.
In 3 minutes. The reality is we're running out of time. We have covered a few of the states in the presentation that you guys will all receive. And if your location is not included, please feel free to contact Lisa and I, and we can help you with that. Many of them have similar benefits like CASPA does. I did want to answer one of the questions that we received, which is what type of projects CASPA covers. CASPA covers all private work. That includes residential or larger residential contracts. That includes commercial contracts, industrial, etc. As long as it's not being funded by public money. If it's being funded by public money, the procurement code would apply. So with that said, let's just skip ahead to the conclusion. The key for any payment situation is to know what your rights are under your contract. It is critical to get the owner contract if you're a subcontractor, and it is critical to know what your rights are with regard to liens, bonds, payment acts, etc. All of those things must be in your arsenal in the event payment slows down or becomes non-existent. You have to know when you have to make a claim. You have to know when you have to file for a dispute, etc. Someone needs to go through your contract at the start of every project and figure out what your rights are under that contract. So you should always try to negotiate the payment terms of your contract. You'd be surprised what you can get. I've successfully negotiated with the Turners and Skanskas of the world to get them to change their terms. Focus on early problem identification. Lisa suggested working closely with accounting. We find that invaluable. It is extremely important that one side of your business knows what the other side is doing. If all they're doing is signing waivers every month in order to get payment and are not filling in the form correctly, as we've suggested, you are going to lose your claims. Your knowledge gives you leverage, and doing nothing loses that leverage. The longer you go into the project, the harder it is to recover. And we received one other question relating to contracts where there's a change in scope of work, and whether or not the sub has to accept that new work, and also whether or not markup limitations on private jobs are legal, or enforceable, I should say. The answer to those questions, unfortunately, are that if the change in the scope of the work is actually within your scope and the other side disputes it, um, most contracts require you to proceed. If the work is not within your scope, let's say you're an electrician and they say you're supposed to provide a boiler, um, you have arguments that it's completely out of your scope and you shouldn't have to do it. But you are basically buying yourself a lawsuit, and it makes sense to sit down and see what is going on and why this is happening. With regard to the limitation on overhead, yes, that is enforceable. Um, you need to renegotiate that at the time of contract. We see more and more owners requiring subcontractor limitations on markup being very, very small. So negotiate, negotiate, negotiate. And with that, uh, I wanted to thank everyone and to thank Lisa for participating in this seminar. We hope that everyone enjoyed it. If you have any questions, please feel free to give us a call or to send us an email, and we would be happy to help you. With that, Lisa, do you have any closing comments?
Other than we just got another quick question here about doing a job in New Jersey where the general is in Pennsylvania. And it looks like they're trying to push the CASPA rules on a New Jersey project. CASPA cannot apply in any projects that are not in Pennsylvania. So a New Jersey court would not enforce CASPA terms for a project that is in New Jersey. So I hope that answers your question. It would not be enforceable. I mean, if they won't strike it, rest assured that they will have a difficult time having it applied by a New Jersey court.
And you should be aware that New Jersey has a version of a Prompt Payment Act as well.
And I believe that I don't want to speak out of turn, but I don't know that you can waive the New Jersey Prompt Pay Act either. But yes, so I mean, they could, on a New Jersey project, they could try to enforce the New Jersey prompt pay laws on that project, but just not the Pennsylvania CASPA. And just to reiterate what we started off the webinar, we will be getting an email follow-up for those who participated with a link to this presentation today. So keep your eyes open.
All right, well, with that, thank you very much. We will be having another CCRM webinar later in the year. So please look for notification of that upcoming webinar. Thank you.
Thanks, everyone.